Okay, so welcome back. Right now we're doing part 2 of chapter 6, Agreements in Writing. We're looking into next section here is relief on the effect of non-compliance. There are 3 known ways to obtain relief from the effect of non-compliance. First one is the doctrine of past performance. Second, doctrine that states that the statute of fraud cannot be used if it is used to commit a fraud. And number 3, remedy of restitution. The doctrine of part performance states that it would be waived compliance with the statute in situations where it would be unjust to refuse the enforcement of the agreement. A common example is a common example in this case is the transfer of land in exchange for a set of service. Okay, the second doctrine, parties are not able to use the statute of frauds in order to acquire property if it would be inequitable for the acquirer to retain. A common example in this case would be the use of trust agreement. If the person acquires a property if a person acquires a property, know that it is acquired in trust of someone else. The acquirer cannot rely on the statute of frauds for the proposition that the informal trust agreement is unenforceable in order to retain the property. The acquirer will hold the property on a constructive trust. Alright, here's a real life case, okay? My grandfather owns a lot of land in China and Taiwan. My great-grandfather, okay? When he passed away in the mid-1950s, he owned a commercial building in downtown Taipei. So this commercial building in downtown Taipei was put in trust of his good friend from the KMT party. The building was rented out and income was used to maintain my great-grandfather's gravesite. The land was supposed to be transferred back to my grandfather and his siblings. My grandfather's brother passed away a few years ago, and his sister gave up on the rights on the land. So the question is, does my grandfather have the right to those land? If yes, how can he get it back? It has been more than 60 years and my grandfather is very old. Well, question. Anyway, back to the idea, back to the relief on non-compliance. The third relief is the remedy of restitution. The remedy of restitution requires a party who transfers something of value to another to recover that value in order to prevent the unjust enrichment of the other party. Page 174. Okay? Alright, I'm going to skip through talking about incorporation and stuff because we're not going to be looking too much on that. Skim through it a bit. But I also want to talk about the parole evidence rule. The parole evidence rule is a rule which determines whether terms in the agreement are to be included in the agreement. Should the written evidence be used as a source of the terms of the agreement? There are 2 versions of the rule: the modern approach and the traditional approach. Okay, the traditional approach states that a written agreement appears on its face to be a complete agreement. The parole evidence cannot be used to contradict, vary, add, or complete an agreement. Well, it can add or subtract from the terms of the agreement. Okay, that's page 195. The traditional parole evidence rule prevents a party to a contract from later adding a term previously or concurrently agreed upon, but it is not included in the final written contract. It is meant to preserve the integrity of the contract. Before the contract is completed, there is a bargaining process in which terms are being negotiated orally or in writing. Once the terms have been agreed, the contract is written and signed by both parties. It could be that one of the terms previously agreed has been omitted from the master contract by mistake. Perhaps a typing error. The parole evidence rule is there to protect the terms of the contract. However, the traditional parole evidence has been criticized for its unjust outcome. The two cases of the Supreme Court that took the traditional parole evidence stance are Harris versus Montreal Bank and Bauer versus Montreal Bank. Both cases concerned the enforcement of the bank guarantee. Okay, the second approach is the modern approach. The modern approach focuses on the need to demonstrate that the parties actually intended to reduce their agreement in writing as a precondition to the application of the rule. Page 195. The modern approach will allow prior communication of relevant to the case to be admissible. This would mean that the written prior communication is a valid form of exclusive source of the agreement. One way to fix the problem of this parole evidence rule is the equitable remedy of rectification. I mean, there is no remedy to the contract, and the parties are held accountable when there is no evidence that the terms were omitted. The parole evidence will prevent parties from adding terms previously agreed upon between parties, but which are not written in the final written contract. The rule does not exclude evidence supporting the agreement. Okay. Now, if the terms of the contract is incomplete or obscured in its meaning, the parole evidence may be used to make clear the meaning of the terms. The evidence can be used to identify one of the parties in the agreement. Alright, that's it for Chapter 6. Until next time.